You hire a contractor who takes your deposit and stops answering your calls. Or maybe a careless neighbor knocks your smartphone off a table and refuses to pay for the screen. You are out hundreds of dollars and you want your money back. Your first instinct might be to hire a lawyer, but when a lawyer asks for a $2,000 retainer to fight over a $500 repair bill, the math doesn't work. The cost of traditional justice is higher than your actual loss. That is exactly why small claims court exists. It is a specific branch of the legal system built from the ground up for regular people to represent themselves. You don't need a law degree to walk through these doors. The filing fees are usually under $100, and you get a decision in a matter of weeks, not years. Once you understand how to navigate this local system, you remove the financial barrier to the courtroom and gain a direct path to recovering your money. To win your case, you have to understand what civil court actually does. This chart shows the split between civil and criminal law. The government uses criminal law to punish illegal behavior. But when you sue someone over a broken contract, you are using civil law. The goal here isn't to put anyone in jail. The objective is compensation. The court looks at your loss and attempts to make you whole, meaning they want to put you back in the exact financial position you were in before the incident occurred. Because the goal is strictly financial, your claim has to be tied to a quantifiable loss. You cannot sue someone just because they were rude to you. You need a measurable figure, like a missed paycheck, a medical bill, or a specific repair invoice. Before you take that figure to a judge, you need to write a demand letter. This is your formal request to settle the dispute out of court, and it is a mandatory first step. Your letter needs 3 specific things. First, clearly state the facts of what happened. Second, list the exact dollar amount they owe you. Finally, give them a firm deadline to pay it. Giving the other party a clear chance to fix the problem shows the judge you acted reasonably. If that deadline passes without payment, you have established a paper trail and a solid foundation to file your lawsuit. Now we enter the logistics of the legal system. Having a valid, documented claim means nothing if you submit it incorrectly. First, check the statute of limitations. This is a strict legal timer that starts ticking the moment your incident occurs. If you file your paperwork after that deadline expires, your case is dead on arrival. You also have to make sure your claim fits within your state's monetary caps. Small claims courts limit how much you can sue for, and depending on your state, that ceiling can be anywhere from a few thousand to over $20,000. Next, you have to file in the correct jurisdiction. You can't just pick the courthouse closest to your house. You generally have to file in the county where the defendant lives or where your contract was originally signed. Once you know the right courthouse, find the exact legal name of the person or business you are suing. Write that name on a statement of claim form, hand it to the court clerk, and pay your filing fee. The court enforces these geographical and deadline rules without exception. If you misspell the defendant's corporate name or file one county over, the judge will dismiss your case before you even get to speak. Handing your paperwork to the clerk opens the case. Now you have to legally notify the person you are suing. This notification is called service of process, and it is an absolute requirement under the law. You cannot drop the papers off yourself or send a text message. You must use a certified mechanism. Most plaintiffs hire professional process servers or use the post office's certified mail system to ensure the delivery is documented. To serve those papers, you need an accurate physical address for the defendant. A P.O. box does not meet the legal requirement for serving a lawsuit. If you cannot provide certified proof that the defendant received the paperwork, the judge will freeze the lawsuit. Failing to properly serve the defendant is the single most common reason self-represented cases fail. If your paperwork is served correctly, you get a court date. Now you have to organize your evidence for the hearing. To win a civil case, you have to meet a specific evidentiary standard called the preponderance of the evidence. In a criminal trial, the government has to prove guilt beyond a reasonable doubt. Civil court is different. Here, you only need to prove that your claim is more than 50. Stick strictly to your timeline of facts and keep your emotions completely out of it. A judge makes their ruling based on the paper trail in your binder. Objective documentation wins the hearing. Theatrical arguments do not. You followed the rules, presented your evidence, and won. The judge signs an official judgment in your favor. But here is the hard reality of the civil legal system. The court does not write you a check. They issue an order confirming the debt, but it is entirely up to you to collect it. This introduces the final hurdle. Some defendants are what the legal system calls judgment-proof. A judgment-proof defendant has no income or assets. A court order against an empty bank account is worthless. However, if they have money, state tools force collection. You can garnish wages, levy bank accounts, or place a lien on their real estate. Because collection is your responsibility, evaluating whether the defendant actually has the ability to pay must be your very first step, long before you file the initial paperwork. Holding a signed judgment is half the battle. You achieve true civil justice when you execute post-judgment tools, reclaim your money, and make yourself whole.